All right, guys. So I'm sitting down here with Jerry Feldman from Mid-Maryland Title. Jerry has an illustrious history here in the state of Maryland, practicing law and working with settlements for years now. Here off of your bio, you've always been passionate about business and helping people. Your grandparents and your parents were involved in business, and you spent your summers kind of running a family-run business. Is that right?
Yeah, I was involved in family-run businesses since I was very, very small, very young, and I've been practicing law for over 40 years.
Wow. And I know that, throughout your history, you accomplished many things, including working in securities and actually working to build a securities dealership out with the Securities and Exchange Commission, ended up selling that after about 6 years. You've owned and operated commercial real estate. You've been a principal in a building, savings and loan bank, and really you've been practicing law for how many years now?
Over 40 years, and presently I'm of counsel to the law firm of Hyatt and Weber, in addition to running the Mid-Maryland Title Company, which is a wholly owned subsidiary of Severance Savings Bank.
And that was something recent that just happened?
Yes, that transaction took place in September of 2017.
Was there any reason that you decided to sell at that point?
So I've been practicing law for over 40 years. I had a law partner that we were partners for almost 40 years, and he passed away. And when he passed away, and I've always had a close relationship with the chairman of the board of Severance Savings Bank and the principal partner of Hyatt and Weber, and we started speaking, and it seemed to be mutually beneficial that I transitioned to become of counsel to the law firm and sell the title company to the Severance Savings Bank and run the title company and continue to practice law as of counsel to the law firm.
Sure. And I know that they specialize in land use and development along with personal injury. But all in all, you've had decades of experience in real estate, commercial real estate, residential real estate, pretty much all around.
Yeah, so in my practice, I've done a lot of administrative work, zoning, land use work. As you mentioned, my late law partner and I started a National Association of Security Dealers, securities broker dealer that we ran until 1981. We sold it to a regional brokerage firm. We developed real estate. We built real estate. We transacted business in commercial real estate and in residential real estate. And it's always been my interest to be involved in business. So it all fell through and blended together.
Sure. So specifically focused on some commercial real estate, is there a settlement or a client that you've been working with recently, maybe over the last year, that really stands out as a really interesting one?
Well, there are many. I mean, in the course of any day, one of the reasons why I like what I do is because, as an analogy, if you watch a sports event and it's a nationally televised game, football, basketball, lacrosse, hockey, you'll hear the announcer go, "Wow, look at what just happened. I've been announcing these games for 40 years. I never saw that before." So in the practice, I mean, sure, a lot of this stuff is run of the mill, but every day you see something, you scratch your head and go, "Wow,
sure.
look at that." So they're all like snowflakes. They're all snowflakes, but every one of them is different. Every one of them has their own oddity.
Sure. Is there a specific example of something where something might, like recently where you said, "Wow"?
Yeah, every day. So I have a client who was selling a large apartment complex.
Sure.
And the client bought the apartment complex a few years ago and is now got someone interested who wants to buy it. And the buyer is doing their due diligence.
Right.
And the buyer came up with a question that was unique and odd. And we scratched our heads and go, "Why is this being asked?" And we looked and we said, that question has no relevance. Well, it appears to be relevant to you now. If you look behind the question,
right,
you see the actual issues involved, and it is a non-issue. Like, they were very excited, "Oh my goodness, we found this incredible issue." But it was like looking at a rock on the ground and saying, "My God, there's a terrible rock here."
Sure.
But then you realize that you can lift the rock up,
And there's nothing.
You can move the rock out of the way, and there's nothing there.
Sure.
And you have to approach it and calmly and see what its real relevance is, and if there is relevance, how do you deal with it?
Sure.
And if you approach it with good faith, with the intention of trying to do the right thing, it'll all work out.
Sure.
So what we always strive to do is look to be fair. If you look for advantage, you'll do one deal.
Right.
But if you look to be fair, the word is you'll be known to do a fair deal, and people will do deals with you.
Yeah.
So you always look to do the right thing. You look to be fair.
That's awesome. So kind of covering, the couple of things that you just talked about, when a buyer's looking at, you said it was an apartment complex. So a buyer's looking at an apartment complex, and in their due diligence period, when they were studying the property before they settled, there was one question that really didn't seem to be relevant. They really dialed in on that, and you realized, even though they made a big deal out of it, you're able to really kind of approach it from a different circumstance. So based on your experience, you're like, well, let's think about this. Why are they asking this question? What's the answer to this? I know there's a certain degree of, a veil that needs to happen with settlements. Are you able to share what that question was specifically?
Well, this was a question about a document that was recorded in the chain of title that restricted the use of the property. But if you read the document thoroughly,
right.
In the interior of the document, buried in at page 7, it is one of the many paragraphs. It says that this restriction self-terminates at X period of time.
Right.
And so you can't pick up the book and start to read it and not read it thoroughly.
Sure.
And when you're a buyer, it's critical that you do your due diligence.
Yeah.
But even more critical, when you're a seller, you've got to anticipate what the buyer will be looking at and wanting and needing.
Right.
So, when I go to play your team,
right.
These sports analogies I like them. When I go to play your team, I look at film on your team. I want to know what it is you do and how you do it,
right.
so that I can be prepared to go play your team.
Sure.
If I'm a seller, I have to basically look at my due diligence to make sure I've got everything together, so that when somebody comes to buy it, I can anticipate what they're going to look at, what they're going to need. Now, that doesn't mean they can't they've got to do their due diligence.
Sure.
But I'm ready. I've got things later. So when they asked that question, I said, wow, that's an interesting question, but that question has been looked at.
Right.
And here's the answer to it.
Okay.
And let's not panic. Let's see what we have. Let's see what the question is, and we'll go through it. We'll work it out. And sure enough, we looked and we said, wait a second, of course. But have you read the entire document? Did you look to see
right.
what this meant? It's self-terminated.
Right. That's interesting. Really diving into, I like your analogy of sports, watching film before you play them. For you, you're somebody who's owned and operated commercial real estate as well as worked in real estate law for decades and running a title company. Is there any, advice on how you would watch film for the other party? I mean, let's say I'm a buyer and I'm looking to buy an apartment complex, because that's an example that you came up with. And the owner of that apartment complex is an investor that owns a number of properties in the state. And maybe it's just one owner that has these properties through some LLCs. How would you go about watching that film?
Well, so many different parts. Okay, first you want to make sure that the title is good. You want to make sure what affects the title. When people look at a title policy,
right.
The title policy should say, we will ensure that this person owns the property. But key to that is, we will ensure they own the property subject to these exceptions.
Right.
And the exceptions are typically that the gas and electric company has a right to run power to it.
Okay.
But did you look at that gas and electric agreement? What does it say? Does it say that they have a right to come onto the property at any point? Does it say that where they come onto the property is restricted to a specific area? Are there any easements, covenants, conditions, restrictions? Are there any documents that create a right in someone or some entity to affect this property? And what is the meaning of it? And how will that affect your ability to use the property or further build upon the property or modify anything upon the property? So those exceptions are key. It's not enough to say, here's the title policy.
Right.
You then need to turn the page and look to see what are the exceptions and how will they impact me.
Sure. So, as a settlement officer, managing a settlement, are you, for the title policy that you pull together, are you pulling these agreements and these covenants and then delivering them to the buyer, and it's their responsibility to do their diligence, or how does that process work?
So I pull it all together,
right,
and I make the buyer aware. It's not enough to just pull it together and list the exceptions.
Sure.
The buyer is. The buyer doesn't read x-rays every day.
Right.
So the buyer is hoping that the physician or x-ray tech will explain, these are the things that we see on the x-ray.
Right.
And these are the things that will impact you. And you don't do that at the day of settlement.
Right.
You do that during the due diligence period.
Sure.
Like, okay, let's look at all these agreements and how do they impact and what do they do and how do they affect me.
Sure. You mentioned easement, and you mentioned how it's your job to pull it together and inform the buyer, and then allow them to make a decision. And you don't do it right before settlement. I just had a settlement where there was a sewer easement and a driveway easement, and they sent over the agreements, but they were missing the exhibits. And the exhibits were the exhibit of the sewer easement was not a professional survey. Let's put it that way. They used an aerial photo and drew lines of where the sewer is. It was something that was very interesting in terms of how that was delivered. Working with easements, have you ever had interesting experiences where you now know how to help a buyer navigate an easement based on a past experience that you had?
Well, yeah. So I have a situation I'm working on now where there's a piece of commercial property, and the question is, how do you access this property?
Right.
And because you need access. I mean, one of the things that you want to know is, where's the access to a public road for this property? Do you need to come over someone else's property? Is there a recorded easement to allow you to come over the other person's property? If there is, who maintains it? Who's responsible for it? And so often you'll see that, that guy told me that I could come across his property. Well, we deal with real estate, we deal with something in common law called a statute of frauds, which basically just means anything you do needs to be in writing, properly acknowledged.
Sure.
So it's not just like, oh, he told me. Where did he tell you?
Right.
Did he have the authority to tell you?
Right.
Where is that authority acknowledged, that he signed it, that someone said, yes, that was John Jacob who told me that, and John Jacob appeared, and then is it recorded?
Right.
Because if it's merely drawn on a document, a plat doesn't convey property. A plat shows where the property is.
Sure.
But you need instruments signed, sealed, and recorded.
Sure.
To create the rights that people and the easements and responsibilities that people are saying that they have. So you find, well, where is it? Yeah, you can drive across that, or there's a road there.
Sure.
Well, okay, there's a road there, but has it been a road that someone has previously acknowledged, or is it a road that I need to get acknowledged?
Right.
Because when you need to go get somebody to acknowledge it, that's when they start to scratch their head and go, well, what's it worth to you? What's it worth to me?
Right.
You don't want to be in a position
to have to negotiate that.
To have to negotiate it. You want to know in advance.
Sure. So you mentioned, when you're pulling together a title policy and pulling together any potential easement, lien, or encumbrance on that property, it could be something as simple as, our local utility company has the right to install power and, work on the property at any time. It could be something as complicated as, how do you access the property when there's, lots of different people using that access, and you mentioned, is it recorded, and how, through the securities of fraud, was it?
Statute of
fraud, excuse me. The statute of fraud, how are you proving that it is what you say it is, and are there third parties that have kind of recorded that? And so, for these circumstances, if you own a property and you think you might have an easement, or you think you might have an encumbrance of some sort, at what point do you feel that you need to have it recorded with the state or even your local municipality?
Oh, it should be recorded. It's got to be recorded, because you can think you have it.
Sure.
But you want to know you have it.
Yeah.
You don't want to think. You don't want someone saying to you, "I think it'll be okay." Well, you're the one taking the risk. You want to know that it's going to be okay.
Right.
So when someone says, "Oh, it should be okay," No. Right. You want to know it will be okay.
Yeah, absolutely. Has there ever been an experience with an encumbrance or an easement, where it really stumped you for a minute and you really had to? I mean, could you provide an example of something that was really complicated?
No, but it happens because you go, well, sometimes these easements are vaguely described.
Sure.
So you don't know where they are.
Like a drawing for a sewer easement.
Yeah.
Using an aerial view.
Or it says that, I give you a right to put the sewer line across my property. Well, wait a minute. I've got a big property. Where?
Right.
You need to get it defined.
Sure.
And there needs to be, in order to have a valid agreement, there needs to be a meeting of the minds that the thing I'm talking about is the same thing you're talking about.
Sure.
And the only way to do that is not to assume, but to actually, let's put it down, let's draw it, let's write it up and agree to it, and then get it recorded.
Sure.
Because I think that the easement I've given you to run the sewer is only around the perimeter of my property.
Right.
You think that it's going to be the shortest distance between your property and mine.
Right.
And that's not exactly what I have in mind, So when you see these vague agreements, you go, well, this is going to need to be better defined and better refined.
Sure. I heard a podcast recently. Tim Ferriss, the podcaster and author, interviewed Gary Keller, the principal of Keller Williams. And Gary Keller mentioned when he was discussing his franchise agreements, he said, I don't write an agreement, I write a disagreement. Because the only time you really look at your agreement is when you disagree. And he says, are you kind of reviewing every single aspect of what happens when you disagree?
Well, the key is to remember that it's never a problem until it's a problem.
Yeah.
And then, by definition, it's a problem.
Yeah, exactly.
So if you can anticipate the problem, if when you're going to be a seller, you try to anticipate what are the issues, what do I have, what can I represent? Because the seller is going to be asked to make representations
Sure.
and warranties. What can I represent and what can I warrant? And to the things that I cannot feel comfortable representing and warranting, well, do I need to get that fixed?
Sure.
Or is it okay?
Sure.
And it's not for me, will it be okay for the person who takes from me?
Sure. Perfect. Well, we're coming towards the end here, and I guess if you're a building owner and you're not sure if you have an encumbrance or some type of easement, but you don't have certainty, what would you recommend the steps that they would take to kind of, maybe a professional survey or something of the sort, but what are the steps they would take?
If they're a building owner, you would hope that before they became the building owner, they had a full title examination, they got an owner's title insurance policy, that they had a survey done. And if they had a survey done, there are varying degrees of quality of survey.
Sure.
And the highest standard is an American Land Title Association survey,
okay.
which is the acronym for that is ALTA. So do they have an ALTA survey? Because if they merely have a location survey, there's a degree of tolerance
Sure.
that could give rise to, well, let's interpret where this is in that degree of tolerance. So how good is the information that they have for their property?
Sure.
And they should examine that to better understand where they sit, where they stand, because ultimately they or their heirs or their successors are going to be in a position where they're either going to want to borrow against that property or sell that property. And you don't want to find out later.
Right.
Bad news does not get better with time.
Yeah.
So you want to find out now, what do I need to do to fix this? Is there anything I need to fix?
Yeah.
And if you find out there's nothing you need to fix, you don't have to worry about it.
Sure.
Sleep well.
Absolutely. And have it all together so that when you're ready to sell, you can easily pass over the file.
Right.
Awesome. Thanks so much, Jerry. I appreciate
pleasure.
it.
Thank you.